The top 3 things a young family should think about from an estate planning perspective, from an estate planning lawyer. Number 1, your estate planning documents. What are those? You're probably thinking about a will. You are right, you need a will. Why is that? Because if you are a young family, you likely have minor children. And the minor children are the top concern, the number 1 priority we want to protect if anything should happen to you and to their other parent. So what does that mean? How do you protect your minor children? You make sure you have a will. You make sure you have a will in which you say who would be the guardian of the minor in the event that they are left without parents, if you were to die and the other parent were to die. Why would you need to do that? Well, you can just imagine what would happen if you're gone and the other parent's gone and the minor children are left without a parent. Who's going to take care of them? You want to be the one to say who will be the guardian. You don't want it to be left up to the court without your input or be a part of a big family strife and pulling back and forth who wants to be the parent, who would be best, etc., etc. You know best. Make sure that your will says who the guardian will be in case you're not there to take care of your minor child. Critically important. I'm sure I could tell you horror stories about what happens during that time when the fight is going on. The kids are in foster parents. Suffice it to say, please name a minor guardian in your will. That's probably the number 1 reason why you need an estate plan. Let's talk about another reason you need the estate plan. You need to provide for your minor child. How are you going to do that? Well, your will should set up a trust for your minor child. Your minor child or children can't inherit themselves outright because they're minors, so their money needs to go into a trust. Your will creates a trust for your child or your children. Name a trustee, and that is the person who is in charge of the money that's going to go to the minor children's trust. The trustee manages it for the minor children, make sure that they have everything that they need. The trustee and the guardian need not be the same person, and oftentimes people like to split it up so that there's not just one person in charge of both the kids and the money. It's up to you whether you split up those responsibilities. It is commonly done to add another layer of protection for your children. And when you're saying, well, what money is going to go to my kids? I don't have much money. Give this a thought. Consider term life insurance. How are you going to support these children? When you are young, term life insurance is very cheap. And this is commonly what financial advisors, and I'm not a financial advisor, I'm an estate planning lawyer, but commonly it'll be suggested buy term life insurance. The reason for that is then you know that money will go into the trust for your minor children so that they are not left without support. We've talked about a will to make sure you name a guardian for your minor children, name a trustee for the trust that's going to be part of your will that supports your minor children, and what's the third thing that you need to think about if you are a young family? Living documents. Now, what am I talking about, living documents? Those are what are called your durable powers of attorney for finances for health and your living will or your healthcare directive. Now, why would you need these things? These things come into play, these documents come into play if something happens to you so that you can't manage your own affairs. And that's probably the last thing you're thinking about right now. But car accidents happen, other accidents happen, other medical calamities happen. It does happen, and we hope it doesn't. But if it does, make sure you are prepared so that your family isn't dealing not only with your disability and your illness, but a court-ordered guardianship. Because without you having the necessary living documents, your durable powers of attorney in particular, without those in place, court has no choice but to appoint a guardian for you if you lose the ability to manage your own affairs. And that's a terrible situation to be in. So make sure you have your durable powers of attorney so that you appoint somebody you trust to manage your affairs if you can't. And then the last living document, and I had mentioned it, was your living will. It's also called your healthcare directive. It's also called an advance directive. What that is that's where you put down your wishes if you are at end of life, terminal, permanent vegetative condition, and all reasonable medical efforts have been given and you're just not going to get better. It is a matter of when will you pass. Put it in writing. Do you want heroic measures, or would you prefer to be allowed to pass peacefully and not prolong that dying process? It is your choice, but make it clear so that your family doesn't have to struggle over what would you want. As a young family, you're probably not thinking about estate planning, but you should be.